This is Duke University.
No, I'll do it a half hour.
Hello, everyone, and welcome
quarter
to
of.
this stop in the Federalist Society's Lunch and Lection Series. Today we'll be discussing public interest careers with Mr. Jim Burling from the Pacific Legal Foundation and our own Professor Teresa Newman from Duke Law. They're going to speak much more about themselves, so I won't step on their toes, but thank you again for coming, and we hope to see you every week this semester because there will be an event.
Every week. Are we the kickoff event?
This second event.
For this year. Well, I am really glad to be here in Raleigh-Durham under these circumstances. I've told a couple people the last time I was in Raleigh-Durham, it was around Christmas time. I was trying to get to visit my folks in Savannah, and there was a snowstorm that blanketed the southeast with snow, about this much, and it shut down the airport in Savannah and most everywhere else. So I got as far from Sacramento to Raleigh-Durham, and here I stayed for 2 nights. Finally, Christmas Eve, the hotel told me they were stopping service of all food because they're letting all their employees go, and then I basically have to starve until the day after Christmas when they'd come back. So I got to the Greyhound bus station, and the Greyhound bus station, they were making up routes because all the roads are iced over and jammed. So if you're going to this city, and this city, you're on bus number 11. If you're going this city, and this city, you're on bus number 12, and so on and so forth. I finally got on a bus and spent Christmas Eve in the Greyhound bus station and on a Greyhound bus. So this is the second time I've been in Raleigh. So far, it's been a better trip. So thank you. Now, I grew up in the East Coast, and I grew up with the I read the New York Times as a newspaper, and I actually believed what I read in it. And so I had that kind of East Coast bias. But I always loved the sciences, and I became a geologist, and I got an undergraduate degree in geology and a second major in English over at Hamilton College in upstate New York. And then I got to Brown, got a master's in science and geology there. And then I worked as a geologist. And it's great in some ways. I got to climb up and down hills out in the west all day, looking at rocks, looking at mountains, and collecting rock samples, doing geological maps. But there are a few reasons why I decided that probably that was not what was in it for me in the end. One, the lifestyle. One of the older geologists turned to me one day and said, "You know, Jim, the life of an exploration geologist is a lonely one." And I felt real bad for him and started feeling real bad for myself. I had a girlfriend at the time in Tucson that I have to reintroduce myself to her every few weeks because I'd be out living on the desert somewhere in the edge of the desert in a trailer or worse for weeks, months on end. And it truly was an odd lifestyle when some of the cattle begin to look better than some of the others. And I didn't really want to do that for the rest of my life. I also was inspired by the federal bureaucrats. And I was especially inspired by some of the bureaucrats that I worked with in the Forest Service. And one of the more inspiring moments that I had was at a time where I had laid out a number of mining claims in a project, my company, a big mining company called Amex Exploration. And they had the lock on molybdenum deposits, which is used for lubrication and for hardening steel and high temperature steel applications. And so I laid out a number of claims, and mining claim is a 600-foot by 1,500-foot rectangle. And on each of these claims in New Mexico, you had to drill down a 10-foot hole. You had to do a 10-foot discovery pit, but then it turned into a hole about this diameter right here. And you drill down 10 feet, you put a couple pennies down at the bottom of the hole so you could prove someday that you actually complied with the law that said you had to put a 10-foot hole in each claim. And so I laid down a whole series of claims, and every claim, a piece of it touched a road, a dirt road that was going up into the mountains, a dirt road that was used by hikers, fishermen, hunters, campers, all sorts of people. And they'd be driving up and down this road, and I thought that's great. I lay every claim out so it touches the road. So we could bring up a truck, and the truck would be pulling behind it a trailer with a little drill, so it could stop on the road, drill 10 feet, go up a few hundred yards, drill another 10 feet, go up a few hundred feet, drill another 10-foot hole, and so on and so forth. And it was going to work perfectly. But the ranger said, no, because this area that you put these claims in, it's not a wilderness area. Indeed, it's not a wilderness study area. No, it's a proposed, we're thinking of it to be a wilderness study area, so it might be a wilderness area sometime in the future. And therefore, my role in my forest is that I am going to allow no mechanized equipment or vehicles for commercial purposes. And I looked at him and I said, wait, we got pickup trucks and fishermen going up and down this road all day, and I can't take a pickup truck with a trailer behind it? He said, no, you can't. I said, is that in the regulation? Those are my regulations. So I called my boss. He was in Tucson and I was in the middle of New Mexico, and I said, we can't let this happen. We can sue the guy. Because I really wanted to be a lawyer, I guess. And he said, no, discretion is a better part of valor, and he figured out another way of getting around this new regulation. We hired a bunch of guys, big guys with backpacks, and the backpacks was a drill broken into pieces. And they'd hike up into the area, they'd put their packs down, they'd assemble it all together in a drill a 10-foot hole, and then they put this thing on skids, and they would drag it up by hand, as if they were ponies for or mules for a couple hundred yards, and drill the next hole down. But things like that inspired me dealing with the federal bureaucracy. And I began more and more to want to affect policy and change policy and fight what I was considering at that time fairly insane rules. Also, as a geologist, I didn't really like the idea of being an employee for a big corporation. Now, I love big corporations. I just don't want to work for one. There was a time over Thanksgiving holiday where I was on a drilling project, and I called my boss and said, okay, all the drillers are going home for Thanksgiving. I'm going to go back to Tucson because my parents are coming from Jersey. And he said, no, the drillers might want to continue through Thanksgiving weekend. And I said, no, they're not. I want you to be there anyway. I said, okay. So my parents canceled their plane trip, and I stayed there on Thanksgiving weekend. And naturally, the drillers did not want to drill, but that gave me an opportunity on Friday to go down from the valley. I was up in the middle of the Sacramento Valley, went down to University of California at Davis on Friday, visited the bookstore, and bought a book on LSATs. And so I decided I was going to go to law school. The question was when. We had a lecturer by an economist for the company who came to us and said, well, Amex Exploration is sitting pretty. We own 2/3 of the nation's molybdenum deposits. We basically control the price, we control the market. All we need to do is have a new major discovery every 5 years, and we'll be sitting pretty. Oh, and by the way, we have some competition coming up because all these other copper companies are starting to take out molybdenum, and there's a new molybdenum mine going in here. And I began to look at that. I said, boy, the price is going to crash. So I quit. I went to law school. The price did crash. All the people I was working with got laid off, which is another aspect of working for a large corporation. So I went to law school, University of Arizona, Tucson. Why? I'll come to that in a little bit, why University of Arizona in particular. I was living in Tucson. That was one good reason, but there were other reasons as well. And when I was there, I began to learn about public interest law. I remember particularly I had a civil procedure professor, and he was just terribly upset one day and complaining about these so-called public interest law groups that were funded by corporations and did the devil's work for corporations, for loggers, for miners, and for other evil people like that. And so I raised my hand and said, tell me more about these people. That really interests me. And he was somewhat aghast. And then we had a visitor from the Public Interest Research Group who came to talk about public interest law, and I went to that lecture. I was very interested in that, and I went up to the lawyer afterwards and said, you know, I'm thinking of working for a group like Mountain States Legal Foundation or Pacific Legal Foundation. What do you think of that? And I've only had a photograph to look at his face, like, what? You know, as if I was growing horns and I was the devil incarnate. Well, I was. To him. And these, when I went to law school, was before the days of Federalist Society. And one nice thing about the Federalist Society is that it gives you an alternative views. It brings in people to talk on both sides of the issue. When I went to law school, there was only one side of the issue, and that was whatever side the professor was teaching. And when you have con law, and most of you, probably half of you have had con law by now, and you know, it's a usual con law course. You're fed pablum for a while, and you start trying to digest it. And when we got up to Wickard versus Filburn, I had a terrible adverse reaction, and I couldn't take it anymore. I said, this is nonsense, and everything you've been teaching me is nonsense. Well, needless to say, I was not particularly happy with that professor, wasn't happy with me. But it's my development of becoming an East Coast, fairly liberal elite or effete or whatever, becoming a geologist where I learned the value of working for a living, where I learned that natural resource development is not necessarily evil. I worked at a project we had in Colorado near a little ski town called Crested Butte, and it was a very controversial project. They wanted to put a mine in this pretty nice area. I think the mine would have been underground. It could have been done in a nice environmentally sound manner, but there were all sorts of opponents that were vehemently against it. Some of the geologists, for example, ran into some locals and were hit over the head with a lead pipe one day. And it was very nasty, very acrimonious. And I went home for a holiday and back in New Jersey to visit my parents, and I opened up the New York Times, and the New York Times magazine edition had a spread about the project. And it could have been written on a different planet. It had nothing to do with what I knew to be the facts on the ground for having worked on the project. And so between that and law school and cases like Wickard versus Filburn, I became more and more conservative, if you will, more and more libertarian-oriented, because I'm not a true conservative, not a true libertarian either. But I began to explore the idea of public interest law. And I think that public interest law really depends on what you define as the public interest. The term public interest had been co-opted for a long time by a series of fairly liberal left-wing groups who dominated the idea that we represent the public interest. And this is how matters stood up until the 1970s. And it was with Ronald Reagan, when he was governor, he had a particular concern about public interest lawyers and public interest law. He tried to he actually did enact welfare reform. And the welfare reform that Governor Reagan adopted was essentially to provide more money to fewer people, tighten up eligibility requirements, but increase the amount of benefits they received. And Governor Reagan did not want anybody in the welfare establishment coming up with the reform ideas or defending them when they got sued. And they were sued by, the state of California was sued by a number of public interest groups, arguing that the welfare reforms violated various civil rights of the people who had received welfare. Governor Reagan tapped attorneys outside of the welfare bureaucracy to defend it. Particularly, he tapped people in the Department of Transportation, some good lawyers there. And they talked and they had some discussions, and the Attorney General, former U.S. Attorney General Ed Meese, Governor Reagan, and a few other people came up with the idea of having an alternative public interest law firm, a law firm that would represent people in the middle, if you will, the more of the pro-business, pro-free enterprise viewpoint, which is also part of the public interest. And that is the genesis of Pacific Legal Foundation in 1973. It was formed from a very few people getting together, trying to have a counterpoint to the existing public interest movement, which is why when I went to law school a few years after it had been formed, my civil procedure professor was so aghast when he learned about this so-called public interest law firm starting in California than some of the others. But I would suggest to you that the idea that public interest lawyers can defend property rights and can defend economic liberties is older than the Republic itself. And I would also suggest that public interest law had its genesis 250 years ago this year. There was a great patriot named James Otis, and he was one of the early patriots seeking to have freedom for the British subjects in the Americas. He had it all. He was wealthy. He was the equivalent of an attorney general's position. He was part of the establishment writ large in colonial America. And he was tasked at one point to defend the writs of assistance. And he looked into it and he could not defend it. In fact, he became one of the principal attorneys opposing the writs of assistance. The writs of assistance enabled the government, the British government, upon any information, rumor, or belief, to go into somebody's home and look for contraband, material that was where the tariffs had not been paid, that were imported from countries where you're not allowed to import goods and materials from, such as France. And the writs of assistance gave the British Crown and the British troops the right to basically inspect anybody's home on the slightest pretext whatsoever. And if you had a neighbor who didn't like you, the neighbor could inform upon you, and then your house could be searched. And many people did have contraband material. One of the great enterprises of colonial people at that time was tried to get around the British tariffs. So James Otis went into court, and he argued in a famous speech against writs of assistance that now one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and while he is quiet, he is as well guarded as a prince in his castle. And his opposition to the writs of assistance really set a spark off. John Adams said that speech that he gave was the child of independence was born that day when he gave that speech. And so James Otis, I consider to be the first great public interest lawyer in America, and he defended individual rights, private property, and the right of people to be free in their homes. We at Pacific Legal Foundation, what we value are the values of classical liberalism. We defend free enterprise. We defend the right of association and the right not to be associated with a cause which we do not believe. We had a case, for example, challenging the State Bar of California at the U.S. Supreme Court. State Bar of California used our mandatory bar dues for political purposes. Back when we had a Chief Justice named Rose Bird, who was quite liberal, and she was subject to re-election, and there is a strong movement to have her tossed out, the State Bar used our monies to support her re-election campaign. And we thought that was violative of our right not to associate. It's tyrannical, as Thomas Jefferson said, to compel somebody to contribute to a cause in which that person does not believe. And so we won that case at the U.S. Supreme Court. We won on the argument that our dues cannot be compelled from us to support other political purposes. And what we're primarily known as supporters of property rights. But property rights by itself means nothing. I mean, what do we care about somebody's property? But the U.S. Supreme Court and the Founding Fathers and a lot of people in between have known for a long time that, and I'm going to quote from a Supreme Court opinion from 1972 called Lynch versus Household Finance, the dichotomy between personal liberties and property rights is a false one. Property does not have rights. People have rights. The right to enjoy property without unlawful deprivation is just as serious as all of our other liberties, and one cannot exist without the other. And the Supreme Court has made that clear. James Madison, he wrote an essay on property rights in 1792, and let me just read from this a little bit to try to give you an idea of what animates me when I go into court to protect property rights. This term, in its particular application, means the dominion which one man claims and exercises over the external things of the world, in exclusion of every other individual. In the larger meaning, it embraces everything to which a man may attach a value and have a right, and which leaves to everyone else a like advantage. In the former sense, a man's land or merchandise or money is called his property. In the latter sense, a man has a property in his opinions and the free communication of them. He has a property of peculiar value to his religious opinions and in the profession and practices dictated by them. He has a property very dear to him in the safety and liberty of his person. He has an equal property in the free use of his faculties and free choice of the objects on which to employ them. In a word, a man is said to have a right in his property. He may equally be said to have a property in his rights. And where an excess of power prevails, property of no sort is duly respected, and, yes, and then he would continue to say, property of no sort is duly respected, and our freedoms are not safe either, where there is an excess of government power. So much for the Nook. Anyway, this is the sort of ideas that animate what we do defending property rights. When I started working for Pacific Legal Foundation 28 years ago, it was part of a what we call the College of Public Interest Law. It's an internship program for new law school graduates. And I have some brochures that I've left out back. I encourage you, if you're all interested either in becoming a public interest lawyer or just finding out more about Pacific Legal Foundation, to pick one of these up. And I started out at this 2-year fellowship, figuring after that I'd go out and get a real job. That was 28 years ago, and I've still been looking for a real job, but haven't found one yet. Public interest law is what's provided me an opportunity to litigate in a number of cases. Various state Supreme Courts, the U.S. Supreme Court a few years ago in a case called Palazzolo versus Rhode Island, where I defended an individual who had approximately 18 acres of wetland, and the state of Rhode Island said he could not develop those because his development would serve more of a private interest than a public interest. And I thought clearly that that was a regulatory taking, so did he, and we took that to the U.S. Supreme Court. Opportunities to argue cases at the U.S. Supreme Court do not come very often to attorneys in private practice. In fact, they rarely come to attorneys in private practice except in a very elite bar. But we have had a number of cases at the U.S. Supreme Court, 7 so far. Our last one was argued by a 33-year-old attorney who did an excellent job in a case called Sackett versus the United States, dealing with some wetlands up in the state of Idaho. A 33-year-old attorney arguing a case before the U.S. Supreme Court is virtually unheard of outside of the public interest bar. Damian Schiff, who argued the case, is a very accomplished attorney, very good on his feet. He did a fabulous job at the argument. But as I said, most firms, it's not going to happen. Somebody that young who'd been practicing only 7 years gets to go to the U.S. Supreme Court. But we were quite confident that he was the best person for the job, and indeed, looking at the arguments, he was. But the Sackett case is a case that I like to use this example because it exemplifies why there is a need for public interest lawyers to defend private property rights. The Sacketts were a couple of ordinary means in Priest Lake, Idaho. He is a contractor that basically runs heavy equipment. They bought a half-acre lot. It was about a few hundred yards from a lake. There were houses and a street between them and the lake. There were houses on either side of them and a house to the back. It was a residential subdivision built out with utilities already hooked up. And they decided to build a 3-bedroom home on this half-acre lot. And 3 days after they began, they got a visit from the EPA ordering them to stop their work because their property was a wetland. Now, Mr. Sackett is a contractor. He knows wetlands, or he thought he did. He didn't think there was a wetland there. He went out and got some experts. One expert said, well, there might be wetland there. Then he got a more sophisticated expert who dug some holes, took some tests, did soil sampling, and that expert determined there were no wetlands there. So the Sacketts tried to contact EPA. EPA said, no, we're sorry. EPA eventually issued them a compliance order. The compliance order said, you are violating the Clean Water Act. You shall remove the fill that you put onto the wetland. They put some gravel down to make room to put the pad on for their house. You will remove the wetland. You will replant your property with wetland vegetation. And you're going to have trees at a certain height at, I think, 16-foot centers, and you're going to do that. Then you're going to fence the property off, and you shall wait 3 years. At the end of 3 years, you may apply for a wetland permit. And if we grant you a permit, then you can build your house. If we don't grant you a permit, then you may appeal. The Sackett said, we don't want to spend $27,000 clearing the property, another few $10,000 to plant it, put a fence off, wait 3 years. We want to go to court now to determine whether or not our property is a wetland. EPA said, no, you cannot do that. This is a compliance order. Oh, and by the way, if you continue to violate the Clean Water Act and every day your fill is on the property is a day of violation, you're subject to a fine of $32,500 per day. With inflation, that is now $37,500 days. In addition, because if you will be violating the compliance order, you are subject to an additional fine of $32,500 a day. Now, today, it's a total of $75,000 per day that they have fill remaining on their property. And this is 3 days' work and a truckload of gravel. And they're getting fines now that are over $80 million for their half-acre lot. The EPA is defending this and saying, well, this wasn't final agency action. We were simply warning the Sacketts that they may be in violation of the Clean Water Act. Yeah, we already made up their mind that they are, but we gave them a warning letter. And this wasn't an order. We were simply suggesting that they remove the fill so they can get out of noncompliance, so they can, suggesting that they put the trees on there, and explaining to them in a nice way that they could be fined $75,000 a day. At oral argument, the court was rather unimpressed by the U.S. government's argument. At one point, Justice Alito turned to the solicitor for the United States and said, now, if I were to tell this story to some landowner, wouldn't their reaction be that this couldn't happen in the United States? So this is a case where we represent property rights, we represent small landowners. It will have a positive impact on every landowner in the country who has a problem with the Corps of Engineers and wetland, but we think it is important that individuals who are caught under the wheels of the bureaucracy receive representation, just as it's important that people who are caught under the wheels of a welfare bureaucracy or the criminal justice system receive counseling and receive their day in court. The Sacketts could not afford the costs of public interest law. Public interest law, for me, has been very satisfying and gratifying. Now, for students at Duke University, I would encourage you to go into public interest law, but I realize there are some problems and some impediments that I did not face. And I'm going to throw out some numbers. $550, $47,600, roughly. $550 is the cost of 1 year of tuition at the University of Arizona in Tucson when I went there. That's why I chose University of Arizona. Okay, I mean, a private school would have cost me, $5,000, $10,000, but $47,600. Okay, two other figures: 250 versus well over 100,000. I had credit card debt getting out of law school of about $250. True, I lived on peanut butter for quite a while, but I didn't have much debt. $100,000. Many of you have loans that are at that amount, exceeding that amount, or will reach that amount. So how does one, with those sort of financial requirements, go into public interest law? And it's difficult. Now, you can get tuition waiver, you can get waivers of your loan payments, and you can get deferments of loan payments. That helps. We don't pay a poverty wage. We pay more than a number of public interest law firms that start out $55,000. But if you have $200,000 in debt, $50,000 is going to be tough to cut it. I think it's unfortunate that the legal profession has become so expensive to get into, much more expensive than when I was a student with $550 a semester. To be fair, though, that did go up to $600 my second year. And it would have been $650 my third year, but students on law review got a stipend, so I didn't have to pay anything. My last year of law school was free. I do sympathize with law students getting out of school now in a tough job market, but I cannot imagine an area of law that could be more satisfying than me in public interest law defending the rights of small individuals. I've had cases for a few years, just to give you a final example before I turn this over, where I represented a series of gold miners in Alaska. These are mom and pop gold mines. Their family worked on the mines in the summer. They had a few employees, and they would work out in the middle of the boondocks in Alaska. At one time, the Park Service was expanded in 1980 to cover up and swallow up a lot of very active gold mines. And Park Service employees did not like the fact that the Park Service continued to allow the mines to operate. So the Park Service employees went to the Sierra Club and said, "Sue us." And the Park Service was sued by the Sierra Club. And the the Park Service played the FIDO defense. I think you've learned that in civil procedure. That's when you roll over and play dead. We intervened on behalf of the miners. And I traveled throughout the state in small airplanes, visiting a lot of the small mines, giving them strategies and techniques they needed to stay alive during the period that the lawsuits were going on. How many other people have had an opportunity to practice law by flying with bush pilots to remote areas of Alaska, talking to gold miners and talking to them about legal strategy? You know, after I get a group of them together, the first thing they'd want to do is go out and kill the federal judge who had issued an injunction. I'd talk them out of that. The judge is too far away. You can't do that, and that's not going to help your cause. And then I would show them forms that they could fill out, and I would teach them how to fill out
And it's against
affidavits.
the law.
Oh, and it would be wrong. And you know, very, very bad idea. But you know, I did have a hand raised. It said we should get the judge. We should kill the judge. And I said, no, bad idea. Very, very bad idea. And I was able, though, to give them legal representation that actually accomplished for them what they needed to keep their minds operating and opened during the periods that there were injunctions in place, and to show them there is a better way than striking out or lashing out against the government, that you can go to court and you can get justice in court. Thank you very much.
I feared I was going to have to follow the despairing discussion about how much debt everyone carries. And so I was thinking, okay, how am I going to overcome this? And then he talked about being the lawyer to gold mining, bush piloting people, which is even harder to follow. But in any event, just lest you think that he's a time grabber, and he's taking 30 minutes and I'm getting 15. I think it's important that you know that's by design. He is the headliner. I am what I thought until this morning I was going to be the cleanup batter. And I was discussing that with my spouse, and I said I'm feeling like I'm the cleanup batter, until he told me that that's not very complimentary to the person who comes before you. Because we should assume that the headliner knocks it out of the park and that I then am just up at bat. Not that I'm trying to bring him home. So I'm not the cleanup batter. We decided color commentary. I'm just your local commentator. Because I think he did hit it out of the park. And a couple of things, before I talk about what I came prepared to talk about, a couple of things I want to say. I really liked your point about the Federalist Society. I complimented Phil the other day on how robust an agenda the Federalist Society has had this year. There have been, as far as I thought we were the kickoff team for this semester, but we can be second. But there have been many topics that I hadn't seen the Federalist Society bring to the law school before, so I appreciate that. I do want to tell you all that when a student saw my photo, and now that you see what I look like today, some of you know this, that lovely photo out there is about 10 years old. That's why I agree to speak every once in a while, just so I look really good in the hallway. But somebody who saw that poster said, thought for a while that we were going to debate doing public interest law, and that the Federalist Society speaker was going to be, don't do work in the public interest, and I was going to have to take the position that we should work in the public interest. So just to show you how far the Federalist Society has come, they are presenting, a very, I think, so far at least, robust discussion on the value of public interest. So thank you for that. The second thing I want to say by way of introduction of myself is that, as I did tell Phil, I'm not a good person to be a speaker on this topic. So if you want to leave now after your Chick-fil-A sandwich, I would excuse you. But I'm not a good person to speak about on the topic of why I chose choosing public interest for my life career, because unlike my thoughtful panelist, I wasn't very thoughtful. Maybe I'm still not a very thoughtful person, but I wasn't very thoughtful about my career choice. I was a teacher of English before I went to law school. I didn't come to law school until, and you can do the math and figure out how old I am today pretty soon, but I came to law school in my early 30s when I already had my children. They were 2 and 4, and I started here at Duke Law School. I had no idea what lawyers did for a living, very little idea. I did grow up watching Perry Mason, so I had some idea what lawyers did. But I didn't have much of a sense of what practicing lawyers did. I knew that I was drawn to the study of law and the stories of law and the discipline of law. And I loved being a law student. I even liked being a first-year law student. So that already, now if you want to leave, you can leave. But I loved being a law student, but I was never thinking, well, what am I going to do? And as I'm sitting in this class loving, I loved property law, for example, but I think it was my teacher, but I just loved all the first-year courses. I didn't think about, well, how is this informing my decision about what kind of law I'm going to do? And I didn't think about it for a while. We had almost no discussion very limited discussion in the building at the time about careers, legal careers alternative to big firm practice. We had no clinics when I was a student here. We didn't have a dean of public interest and pro bono or an office of public interest and pro bono. So we basically studied law and had very good lunchtime speakers, some of whom talked about the public interest, and I was drawn to those talks. But we didn't have much discussion about alternative careers in the law. So I went the easy way. And after I graduated, I was fortunate enough to have a federal clerkship, and I did that, and I loved that. I'm a person who loves life mostly, so I'm a pretty happy, optimistic person. So I like what I'm doing in the moment at most times. I didn't love changing diapers, so I think that's why law school looked like a really good alternative to that. But I clerked, and then I went to work for a big North Carolina firm because I lived in North Carolina, and though I enjoyed that work, I quickly realized that what I was missing was the thing that sort of drives me as a person, and that's working with and for people. I like people very much. I like their stories very much. I like the intersection of people's stories and the law. And so I thought, well, maybe I should return to working with students in a collaborative model. I came back to Duke, and I've had a lot of different responsibilities here. Fast forward to when I was about in the middle of an associate deanship. I became the associate dean for academic affairs, a position I had for about 9 years, which is and I think Professor Beal, who's in the room, was senior associate dean for academic affairs maybe a couple of times for this institution, and she can attest to the grinding workload of that office. So you are sort of the assistant principal to the dean, so everything, you're responsible for stopping everything from getting, moving up to the dean. So that was my job. I was also the director of the writing program. I also worked with all of the journals. I was general editor of some of the journals. I also taught legal ethics and was the director of the ethics, the very young ethics program at the time. So here's how I became involved to the extent I've always volunteered. I've always done some limited pro bono work as soon as I became a lawyer. But this is how I became, and maybe you don't know what I do now, but I'm the co-director of the Wrongful Convictions Clinic. I advise, faculty advisor to the Innocence Project, associate director of the Center for Criminal Justice and Professional Responsibility. I am the past president of the Innocence Network, which is the national organization that has about 65 innocence organization members now, still on the board of that organization, founding president of that organization, though Barry Scheck and Peter Neufeld actually founded it. Or they inspired us to develop it. So that's who I am today. I had no criminal law experience. I worked in a big firm in litigation. This is how unthoughtful your speaker is. I became a member of a litigation practice group. And some of you, I hope that some of you out there are saying, oh, thank heavens, there's somebody who's landed well and she hasn't given much thought to her, because not everyone is as thoughtful as my colleague here. I think it's all those lonely nights in geological exploration that led him to have a life of the mind. But the rest of us, some of us just live our lives. In any event, now I forget where I was. I went off on this geological exploration. I joined this litigation practice, and I hadn't taken trial practice, as Professor Beale laughs. That's how unthoughtful I was. I wanted all those big classes. I wanted everything that was offered. I wanted to stay another year, but they booted me out. And yes, tuition was lower then, though I wasn't a person of means. I had these children. I was married, but I took out some loans. So when I left the law firm, which didn't, by today's standards, it had a modest salary, but it was a good salary then. I took a pay cut to come here because I knew that I needed something else. But in any event, I'm in the dean's office, and I'm associate dean for academic affairs. And what happens is that I get that some students have decided they want to start an innocence project here and answer the call that was put out by Barry Scheck and Peter Neufeld. And the students want to start this project here, and we're going to do it. And I was uninvolved until I responded to an email to the then faculty advisor, a woman named Cindy Adcock, now on the Charlotte School of Law faculty, and a consummate organizer. So she sent out this notice that students wanted to do this, and I was the associate dean. I was like, well, that sounds interesting. And I wrote back to her privately, and I said, I'd really like to be involved to some limited extent. This would be interesting pro bono work, a couple of hours here and there, dabble in it, sounds interesting, and but I can't come to the organizational meeting. Always go to the maybe not, because serendipity leads me to the fact that I didn't go leads me to where I am today. I couldn't go to the meeting. I get the minutes of the meeting. The minutes announce that Teresa Newman has graciously agreed to be the faculty advisor to the new Innocence Project. So I wrote to Cindy Adcock and I said, half joking, but I said, is this my punishment for not going to the first meeting? Professor Beale will remember, at the time we had a problem with, at the time I sent the email, it was an undiscovered problem, but there was a problem with our email system. It used to, when you would send an email, the problem was that sometimes it would reach back and grab that person the last time you communicated. So they'd reach out and get the address the last time you communicated with her. If the last time you had a communication was with a large group, the email went to the large group. So my email went to the whole group of people who had volunteered, all the students who had volunteered to be Innocence Project members. So Cindy called me and she said, they will think the administration is not behind them if you don't agree to be the faculty advisor. And goodness, we want to reward initiative. And so I rewarded initiative by agreeing to be, so then I had to write a contrite email, said it was a joke with my colleague Cindy, my friend Cindy, colleague and friend. Of course I want to honor your commitment and be the faculty advisor. I'm thinking, oh my goodness. But in any event, I became the faculty advisor for the next X years. I worked pro bono. Jim Coleman and I went up to New York, got trained with the students. We came back. We worked pro bono with the student. Well, by pro bono, what I mean is I really did it on top of all my associate deaning. So this became my pro bono effort. And we started teaching the course on top of everything else. And then when I was released for good behavior from the dean's office, we developed the clinic full time, and this is what we do. I'm already running out of time, but I want to run through the things that my public interest work, and some might argue, well, you're getting paid by Duke. Is this really public interest work? You're a teacher more than anything else, and that's definitional. Phil thinks it's public interest work. I'm happy to honor the Federalist Society by agreeing. But so let's just assume that it is for a second. I'll run through. First, the work I find absolutely intellectually engaging. And I think that's true. What I like about a lot of public interest work is that You get to work on a set of problems that are somehow connected. So mine is criminal justice, yours economic and property rights and et cetera justice, but they're connected. And it's so interesting when you can engage in a problem very deeply. So this is my work. Wrongful convictions. It's not narrow, it's broad. It has a lot of, every case that we pick up, it has its own interesting challenges, and but it is connected, and it's my specialty. So it allows you to specialize, and I really appreciate what you said about youth. It allows you to specialize and exceed your expectations at a very young age. When I was writing these notes this morning, I regret that I only have only one life to give. I regret that I got involved in this so late in my career and frankly in my life. I probably will do this for the rest of my life, probably not in this capacity. I'll always have at least one case. But I regret that I didn't discover this, stumble across, get ensnared by this earlier on. You have an opportunity to you don't have to determine what area you're going to specialize in, or you can just experiment and roam around the way I did until something grabs you. So I find it intellectually engaging. And on a less noble level, I love the stories of my work. I taught literature. There are no better stories than the stories that I have, and they're unbelievable. I mean, we always say, if we were writing the novel that comes from the story of this case, we couldn't include some of it because no one can suspend disbelief to that extent. So these are crazy, interesting stories. That also, the work, public interest work, I think generally, I think this can be generalized to much public interest work, and it certainly is true of my work. I grew up in New York, so we should be debating because he's a New Jersey guy. I'm a New Yorker. We can talk about driving later. They don't know how to. They always say that about New Yorkers.
You live in the city. For
I grew up in a very small house on Long Island with three sisters and a brother and one bathroom. So I very early on learned the value of, I've written it down, harmony, consensus, cooperation, and group effort. That's what I think typifies a lot of public interest work. You get into litigation, we get into litigation, but much of even my work, we try to cooperate with district attorneys, we try to cooperate with the police office, try to cooperate with everyone in a case to work justice. We like to say that there's no conservative liberal in innocence work, and that's not entirely true, but that's my starting position, so it's a very cooperative effort. I have more to say, but I'll save that for the next time I'm invited because I think there's going to be some question and answer.
Thank you both. Before we get to the question and answer, I just want to let you guys know about a special opportunity Tuesday morning. We're going to have coffee and bagels with Judge O'Scanlan from the Ninth Circuit. And we're not going to get a poster for it, but you all are invited. And if you want to make sure you don't forget, write down your email address and make sure it gets to me so I can put you on our list. With that, questions for both of our wonderful speakers today. Someone start us off.
I have a question for Ms. Burley.
Yes.
Could you describe a little bit about the business model of your law firm, maybe how it compares to a big firm and how you select clients, how it's funded? I mean, that.
Yeah, we are a 501c3 nonprofit public interest law firm. And what that means is we do not charge any attorney fees to any of our clients. We do ask them if they can afford it to cover expenses, but that's on a case-by-case basis. We get a lot of calls that come in from individuals and from attorneys asking us to look at a case, to take over a case, to represent them at the get-go. And what we will do is the attorney staff will look at each case and vet them to see if that case is going to advance a particular set of priorities we have established. On the area of property rights and regulatory takings, for example, there are some key areas that we're looking at to reform the law in, such as the ability to get into federal court, such as the balancing issues under a case of how you look at investment-backed expectations. And we look to see if a case can be a good vehicle for that. We look to see, of course, if the case has any problems. We like to represent clients who will be attractive clients because the best cases are won by clients that you get from central casting. I mean, I don't want to put too fine a point on it, but the Sackett's are a couple from central casting. We once represented in the U.S. Supreme Court an elderly widow who was in a wheelchair. She was a client from central casting because she epitomized what happens when regulatory bureaucracies grind somebody under. And we can use a case like that to really exemplify what's wrong with runaway regulations. If we decide to take on a case, then it goes to our Board of Trustees. We have an independent Board of Trustees who are composed of attorneys, business people, farmers, ranchers, people of that nature, and they will look at a case and they'll independently say yes or no, you can go forward. Because we are a 501c3 and we do not charge attorney fees, we rely on contributions. We get about 60% of our contributions from foundations, then another close to a third from individuals, and about 10% from corporations. People say that we're in the pocket of the corporations and we're funded by ExxonMobil. I only wish we were. But indeed, we do receive some modest contributions from the corporate sector, but nothing that's particularly interesting. So with that, we have a budget of between $8 and $9 million a year. We have 22 attorneys. We have offices in Sacramento, where our main office is. We have an office with one attorney. We're hoping to make that two. In Florida, near Palm Beach, one outside of Seattle, Washington, and a contract attorney, a very experienced attorney who charges us about a quarter of what he's worth in Honolulu. And we have been operating since 1973. Last 5 years, we've been pretty steady. Through the recession, we've had a couple challenges. We've had to tighten up a little bit, but we have done well enough that we can continue doing what we do, which is suing government bureaucracies. Does that answer your question?
My business model is that we have Jim Coleman and Teresa Newman and great students. That's our business model. And we are seeking funding, and we'll take it from Exxon.
Could either of you speak to what a law student can do now in order to be exposed to the public interest career? You know, maybe they're deciding between the money of the private sector and the work of the public interest career.
A great thing to think about is to become a summer law clerk for an organization like Pacific Legal Foundation or Institute of Justice or a similar public interest law firm, hopefully on the side of defending property rights and economic freedoms against the tyranny of left-wing socialists.
That's all there is, isn't it? The only public interest.
The only kind of tyranny there is, right. We do, I can be a law clerk during the school year for a group like that. A little hard if you're in Duke. I don't think there is, the closest public interest law firms are probably in DC from here, maybe Atlanta. But certainly our summer program is a good idea. Or read about our cases. There's a lot of interesting things to learn about, but volunteering is probably a good way of doing it. And you can even volunteer for a group that you may not be ideologically in agreement with because the experience is good and you may learn something. I think that one thing I like about the Federalist Society is that we'll bring in speakers to debate on both sides of the issue. It's just not my way or the highway. And so I think it's fine if people want to go and look at an environmental group and work for them, even if you have questions about them. I think the questions will be amplified once you work for them, but hey. Get some experience. Do what you can. You're only at this stage in your career once. Yeah, you have a huge loan, but you haven't committed to anything else, and you can always go into private practice, but public interest law firm, it's a little harder to take that once you're in private practice and get used to the lifestyle that private practice can subsidize. It's a little harder to go into public interest law than starting out in public interest law.
I think it's harder for some. Just don't get used to the lifestyle. You use that money. I have several students, and that's one point I wanted to make, is that we have one case that we just filed a massive motion for appropriate relief on December 22nd. Behind that case is a team of about 9 people. I am the supervising faculty member on it. There's a student who's a 2L who's helping me, another student who organized a group of students too, and they're not, the one student is part of the team, the other students are not part of the team, but they helped at the end. And then the rest are all former students who are lawyers. 3 are in big firms in New York City. 1 is in DC, 1 is in Atlanta, 1's in Texas somewhere. It's such a big state, I can't remember what city. But they want to return. They would love to come do this kind of work, I think, but several of them are earning a lot of money and paying their loans off. And they're keeping their hands in the work they love as volunteers. And you can certainly do that for any organization. Mm-hmm. You can keep your hands in it, stay connected to the people who can advise you, and then step out. Professor.
I just wanted to follow up on that by saying that tomorrow's luncheon and public interest talk is by a 1995 graduate who's a partner in Birmingham law firm. He spent the last 14 years with a team from his firm defending a defendant on death row, Alabama's death row. He's going to talk about what that experience was like, how it worked for him and people in the firm. So some people do it full time, and some people find a way to carve out from their private practice career that option. And I'm really hoping that we'll have a good turnout for it, because he's got an interesting story to tell, and I talked to him to come. So, you know, I think that could be an entree into something else, or it could be a long-term option for something.
And certainly your own Professor Coleman did that. He was a lawyer in DC, and his firm encouraged pro bono involvement. I don't think they expected a major partner to do it to the extent that he did, but he got involved in a number of death penalty cases. He then was invited here to teach a death penalty seminar, and he took a sabbatical from his firm. He went back to his firm for a little while, but we were too attractive a group, and he came back. So you know, there are a number of ways that you can feed the part of you that wants to do public interest. One is
full-time.
Full-time.
Any other questions? Any last comments?
One last comment is, my public interest career, the work that I do is really, would be impossible without the work of the students here. They provide the hundreds and hundreds and thousands of hours that go into these cases collectively. And that is, for my work, I always feel a little sorry for the lawyers who came before us, around whom all these errors occurred, but they were so limited in the kind of work they could dedicate to a case, the number of hours they could. We have the luxury of spending countless hours on a case, but it is the students, some of whom are in the room, so I wanted to give them a shout out.
And I encourage you to pick up a brochure on your way out, find a little bit more about Pacific Legal Foundation, and as you go forward in practicing law, do think of why you came to law school in the first place. Unless there's some way you couldn't figure out what else you're going to do, you know, get a passion. I think being a lawyer is as much fun as you can possibly have. So good luck to you all.
Join me in thanking Mr. Jim Berling and Professor Newman.
Produced by Duke University. Online at duke.edu.